Good afternoon. Welcome, everybody, to our Tuesday training. Today, we're going to have Kiersten Smith with the Department of Labor, and she's going to be talking about service animals.
Thank you so much. Well, thank you guys, everyone, for being here today. My name is Kiersten Small. I am an investigator with the Department of Labor and Human Rights. I have been with the
Go ahead,
department
Kiersten,
for,
whenever you're ready.
okay, can you hear me all right?
Two other.
I can hear you.
I can hear
Okay,
you.
all right. Well, my name's Kiersten Small. I am an investigator with the department. I have been with the department for 10 years. I've done a lot of different kinds of discrimination investigations, housing discrimination investigations, investigations related to wage and hour complaints. So a whole wide variety of different issues that I have dealt with and seen. The one thing I have learned in the 10 years that I have been here is really when it comes to any sort of housing discrimination issue, even though you may have a great knowledge on kind of what the standard procedures are, what the laws are, every single case is so vastly different and everything is on a case by case basis. So even though you may know a lot, you never know it all. So hopefully we can provide you guys some great information about the fair housing laws, kind of an overview of what the department does, but specifically related to service and assistance animals and kind of talk about that reasonable accommodation process. So as we go forward today, we're going to first and foremost talk about a little bit about the department. I will kind of briefly go over these first couple of sections so we can really get into the information about those service and assistance animals. But we'll talk a little bit about what the department does, talk about what housing discrimination is, reasonable accommodations and modifications, kind of the difference between those two types of issues, and then we'll talk about those common issues. We'll talk about the common things that we see related to service animals and specifically reasonable accommodations in the form of some sort of service or assistance animal. And then we'll talk a little bit about best practices going forward from here. So just things as, working in the housing environment, trying to make sure that you're aware of some of those common issues so that you can do those best practices going forward. So before I started the department, I just always assumed it was a fairly large department. Quite contrary, it is actually a very small department. We generally, it kind of goes ebbs and flows depending on our staffing, but we generally have about 5 to 10 investigators on staff, and that it covers all of the wage and hour and discrimination issues through the entire state. We have a labor commissioner, and then we also have a human rights director, as well as a director of operations and an administrative assistant. So very small staff, but we handle kind of three main pillars when it comes to the state's laws. We handle the wage and hour division. That's going to be for wages for work performed. So we handle issues related to minimum wage and overtime. We handle youth employment verifications, as well as some independent contractor items, labor unions, employment agencies, that type of thing. The second pillar, and this is what we'll talk about the most today, is discrimination. So we handle any sort of discrimination laws related to employment, housing, public services and public accommodations, and credit transactions. Public services and public accommodations. A public service, for example, could be, let's say, the water department. You believe that you're being discriminated against based on your race or based on your religion. That may be a public service complaint. If it's a public accommodation, it could be some kind of restaurant or a business that you're going in and you believe you're being discriminated against in the transactions that you're receiving or the treatment that you're going through. And so that would be an example of a public accommodation. And credit transactions, those are things like loans, any sort of credit type of transaction. And then the last pillar is education awareness. So that's things like this. We handle a lot of different presentations. We do a lot of different booths. Basically, we provide a lot of public outreach in hopes that we can educate people on the laws in order to prevent them from occurring. So, what exactly is housing discrimination? Obviously, we talk a lot about discrimination, but there's kind of that legal definition, a dictionary definition. So, under the law, housing discrimination is treating someone differently in the sale or rental of housing because of a person's membership in a protected category. So, that's kind of what the all encompassing law of housing discrimination entails. And so, that means that the fair housing laws themselves make it unlawful to treat someone differently in the sale or rental of housing because of that person's membership in a protected category. So when we talk about fair housing laws, there's two major laws that pertain to fair housing. One is the Fair Housing Act of 1968. That's going to be the federal law. So that one, generally, it's enforced by HUD. Also, we have obviously laws that fall under kind of the umbrella of what the Fair Housing Act covers, but that's going to be the main piece for the federal side of things. And then we have the North Dakota Housing Discrimination Act of 1999. That's going to be the state law. So we have a partnership with HUD, which basically allows us to investigate cases for them. It allows them to investigate cases for us. And because of that partnership, we do have to have substantially equivalent laws, which means that basically we can't have any laws
Hey, just a moment.
That contradict or basically oppose anything related to the federal law. And so we really have very, very similar laws when it comes to the Fair Housing Act is going to be very similar to the North Dakota Housing Discrimination Act. So what are those protected categories? So obviously being treated differently in the sale or rental based on a protected category. So these are the Fair Housing Act protected categories. So these are the federal side of things. We have color, race, familial status, national origin, color, religion, disability, and sex. So if an individual believes that they have been treated differently based on one of these categories, then they have a right to file a discrimination complaint with our department or with HUD. So it does have to be based on one of these protected categories. An individual can't just file because the respondent didn't like their shoes or didn't like their hair color. It has to be based and kind of have that connection or nexus between the alleged action and one of these protected categories. So again, these are based on the Fair Housing Act, which is the federal side of things. When it comes to the fair housing laws, we have to, at a bare minimum, have the equivalent of the fair housing laws, but we can have additional protections in which our state does have some additional protections, so additional protected categories. And so in addition to those federal categories, we also have the receipt of public assistance as a protected category, age as a protected category, domestic violence, and marital status, which means that individuals can file on these bases in the state of North Dakota because we have additional or extra protections above and beyond what the federal jurisdiction is. When it comes to that receipt of public assistance, it's kind of exactly what it sounds like. If an individual is receiving some sort of assistance, so maybe it is Section 8 housing vouchers, maybe it's some form of public assistance, and because they are receiving that, they feel that they've been discriminated against, they have a right to file. Age is going to be for age 40 and over. Domestic violence, this is a very specific category because it's only for individuals who are victims of domestic violence that are under a state program. And so it is a pretty limited category, but that is one of the newest coverages that we have within the state. And then lastly is marital status. And an example of that would be if a landlord is saying you can't live here because you're divorced, or you can't rent here because you're single. Those can be examples of marital status. So we are just about to be wrapping up the current biennium. It ends here at the end of June, but this is for the last biennium, the housing complaints that we did have. So we had a total number of complaints of 48 total complaints, or 46 rather. 48 was the previous biennium. And this is kind of the breakdown of what the resolutions were for each of those claims. So as you see from the numbers, the kind of most common resolution for these cases is what we call conciliation. And what conciliation is just trying to find some sort of resolution between the parties prior to the completion of an investigation. It can be any number of forms. It could be that they just granted the reasonable accommodation. Maybe it's that they allowed them to exit their lease without penalty. Maybe it was some sort of monetary settlement. Maybe it was something like some kind of apology or letter of positive reference for any future tenancies, that type of thing. So 19 of those claims were conciliated. 13 were no reasonable cause, which means that based on the facts and evidence, we did not believe that there was reasonable cause that a violation occurred or that there was no violation of the law to be found. 4 were reasonable cause, 4 were dismissed, and they can be dismissed for various reasons. Sometimes if the parties are unable to be contacted, maybe the complainant has moved and didn't let us know they don't wish to proceed forward with the complaint. After several attempts, we may have to dismiss the complaint. 4 were withdrawn with resolution. So those, a lot of times the parties just resolve it on their own. And then the complainant lets us know, yep, I just want to withdraw it because I worked everything out. And so that would be a withdrawn with resolution. Likewise, withdrawn without resolution is if a party's, let's say the complainant says, I just don't want to mess with this. I've already moved out. I don't want to continue forward with this. So they are withdrawing their complaint. There may not have been a resolution, but they chose to withdraw it. So of those complaints that we had 28 of them filed on disability, 10 on public assistance, 9 retaliation, 8 race, 4 sex, 2 familial status, 1 age, 1 national origin, 1 color, and 1 marital status. When you look at these numbers, they do equate to more than the 46 complaints that we had, but that's because many of these complaints may be filed on multiple bases. So you may have a complaint that has allegations of disability and of retaliation, or maybe of national origin, color, and race. So it may be multiple categories on one complaint. As you can see from these numbers, disability is by far the most commonly filed on issue within our complaints, any of the housing discrimination complaints. And of those 28 disability complaints, 24 of them were for reasonable accommodation. So obviously, it's always great to have additional trainings like this because the reasonable accommodation and disability process, those can be multiple trainings in and of themselves just because the amount of information that kind of goes along with it. So being that disability is the most filed on issue within the state, it leads us to what is the definition of disability. Again, this is going to be kind of a fluctuating definition because it is going to be different. It's not based on maybe, oh, I've been classified as disabled because of SSDI, or maybe I've been classified based on my time in the service. I've been classified as being 100% disabled or 80% disabled. That is not the same definition that we are going to look at. Under our laws, we have to look at that Fair Housing Act and the North Dakota Human Rights Act to determine whether or not the individual is a person with a disability under the law. And when we do that analysis, it's a lengthy analysis. We're looking very closely at what the person's conditions are, how they're substantially limiting them or impacting them. But we look at these 3 kind of pieces to it, that the individual has to have a physical or mental impairment that substantially limits a major life activity, or they have to have a record or a history of having such impairment, or they have to be regarded as being an individual with such an impairment. And so when we're looking at these definitions, it's not always going to be something that's obvious. So a lot of times people think disability, okay, somebody in a wheelchair, maybe somebody who's blind, those are visually obvious disabilities. Disability can absolutely be something that is not as obvious as well. So there's obviously some of those mental conditions, whether whether it be anxiety or PTSD or depression. Maybe it's something like diabetes, where their endocrine system is impacted. Maybe it's something related to kind of other conditions. Maybe it's something that they had an injury years ago that has resulted in kind of a long-term impairment that substantially limits them in some way. And so there could be a lot of different people that can fall under the definition of disability. And it really is a very kind of fact specific and case by case basis as to this analysis on whether or not that person is a person with a disability. The having a record or a history of such impairment, that is going to be, maybe they don't actively have the substantial limitation. Maybe they're not actively having symptoms of the disability, but they do have a record or a history of having that impairment. So they could be considered disabled under that. And then that last one being regarded as, maybe they don't actually have a disability, but they're being treated as if they did. So maybe they have an extensive family history of some sort of mental impairment, and the respondent is treating them as if they also have that mental impairment, even if they may not have that or have been diagnosed with it. So it can only be discrimination if the person requesting has a disability, right? No, not specifically. So obviously, we're looking at whether or not a person is a person with a disability, but people can be impacted and file discrimination complaints if they are being treated differently because of their association with a person with a disability. So maybe their son or daughter has a disability and they believe that they're being discriminated against based on that, their child's disability. Maybe it's somebody else who's living in the unit. Maybe it's somebody who even came to visit the unit and they felt that they had been discriminated against based on that person's disability. And so just because the individual themselves may not necessarily have a disability, they still may have an opportunity to file a complaint. One of the other common issues or common complaint types is something like a testing case where somebody calls the respondent, says, I'm moving in with an assistance animal. Can I move in? And the respondent says, no, we don't want any sort of pets, regardless if they're an emotional support animal or not. They could just be a tester that's calling to see what the respondent's response would be. And so those cases, they can be filed on as well. So again, disability is the most common filed basis, and within that, the most common filed issue is going to be reasonable accommodation. So what is a reasonable accommodation? All it is a change, exception, or adjustment to a rule, policy, practice, or service. The fair housing laws do require reasonable accommodations for individuals with disabilities. So basically, they are kind of those exceptions or those changes that allow an individual with a disability to use and enjoy the property just the same as any other tenant. And so failure to participate in that interactive process or provide that reasonable accommodation can constitute discrimination on the basis of disability. Some of the common things we see with relation to reasonable accommodations, as I said before, they're the most commonly filed on issues in our department. So they can be made of current or prospective applicants or residents. So it's not always going to be your tenants who are actively living there. You may get reasonable accommodation requests from individuals who are applying to live at the property or who are, basically seeking more information about the property. So it's not always going to be your current tenants. It can certainly be applicants as well that are requesting some sort of reasonable accommodation. One thing that we look at very closely, and HUD looks at it very closely as well, is respondents addressing these requests in a timely manner. So there's not a set time frame. It's not something that you have to respond within so many days or anything like that, but it does have to have kind of that timely action. Any sort of untimely delay to the process could constitute a violation. So whenever a request comes in, we do look closely what happened. Was the individual who was receiving that request, were they out of the office? So if so, that might be a reasonable time that they waited until that person came back into the office. There still may be obligations to kind of touch base with the tenant, say, yes, we received your request. So and so is out of the office until the end of the month, but they will be in contact with you. Or we are going to have to refer it to somebody else, maybe our attorney, or to the reasonable accommodation manager to be able to assess the request. So we've moved that on to them. So kind of that touch base, but having just that process move forward in a timely manner is going to be very important. The requests themselves may impact just that individual's residence, but it potentially could impact common areas as well. Obviously, things like hallways, you may interact with, like, for example, the assistance animal or service animal. There might be other kind of common areas where it's common community rooms, that type of thing, where if the individual does have some sort of reasonable accommodation, they again are just trying to use and enjoy the property all the same. So not allowing them to utilize some of those spaces solely for purposes of the, let's say, assistance animal, those may not be permitted because the individual, the tenant, is not necessarily getting that same enjoyment of the space. We'll just touch really quick on reasonable modifications. So we talked a little bit about reasonable accommodations. Modifications are going to be those structural changes to the unit. They have kind of the same assessment as a reasonable accommodation process, but again, these are going to be modifications to the actual unit. So maybe it's lifting and lowering the height of the countertops, maybe it's widening door frames, that type of thing. Biggest difference between the two is those reasonable accommodations is that alteration or change to a rule, policy, or practice, and the costs of that are going to be paid for by the landlord, regardless of whether it's public or private. Generally speaking, reasonable accommodations do not have much or any associated cost. Obviously, having an exception to some sort of policy normally is not going to come with some kind of cost associated with it. Whereas reasonable modifications, it's that removal of the physical barrier. And in private scenarios, that is going to be the cost is going to be paid for by the tenant. In certain federal supported programs, so if the building is receiving certain federal funds, they may be required to be paid for by the landlord. But generally speaking, a lot of reasonable modifications are going to be paid for by the tenant. The big thing about reasonable accommodations and modifications is they're not going to necessarily be in some sort of magic words or specific verbiage when they make these requests. You, as a landlord, can't require the tenant to complete, for example, some sort of reasonable accommodation form as a condition of receiving that accommodation. So those are things you're not always going to have kind of that clear and concise language, but if the request is being made, the landlord kind of has an obligation to move forward with that in some way. So what exactly is reasonable? Obviously, that can vary on a case by case basis from person to person. What seems reasonable to one may not be for another. One of the biggest things that we look at is it going to cause some sort of undue hardship? So would it impose some sort of undue financial or administrative burden? Or would making that accommodation require some sort of fundamental alteration to the nature of the provider's operation? Even if the answer is yes to both of those issues, the landlord still may have to provide other accommodation options. But there are ways that there might be the landlord cannot provide the accommodation. It truly does cause some sort of undue hardship because they have to hire additional staff to be able to grant this accommodation, or it's going to be so costly for the size of the operation or business that financially it's just completely overly burdensome, then it may not be a reasonable accommodation. So those are things that we look at. Again, we look at these very closely. So if a landlord says, we couldn't provide this accommodation because it was some sort of undue hardship, we really are going to look closely at, if it's for financial reasons, what was the financial documentation of that? Were the individuals, was the respondent financially saying it was improbable that they could not provide that accommodation to the person. But when we actually get the documentation, really it was a $100 accommodation cost that in a large facility or building would not have posed an undue hardship. We're going to look closely at those assessments. So now for what everyone is here for today. So now that we kind of built up the background of what reasonable accommodations are, what disabilities are, we're going to talk a lot about service and assistance animals. So some information about what to expect with service and assistance animals, kind of what information you can request, any sort of kind of common issues or uncommon issues that come up with service and assistance animals. So service and assistance animals, when it comes to any sort of reasonable accommodation, obviously it's to eliminate some sort of barrier or to eliminate the or to allow the tenant to have the same enjoyment of the property as other tenants. And so individuals who are disabled may require the use of some sort of service or assistance animals. A disabled tenant may ask the landlord for a reasonable accommodation in that no pets policy. So even though the building or the property may be a no pets property, exceptions may have to be made in the fact of the reasonable accommodation request. So again, a reasonable accommodation, they're requesting some sort of alteration or exception to their policy. Their policy is no pets. The disabled individual is asking for an exception to that no pets rule. And again, to deny that accommodation, the landlord must prove that an accommodation is either not reasonable, not necessary, or causes that undue burden on the landlord. When we talk about service animals, so service animals are different than assistance animals. A service animal, by definition, is any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability. Other species of animals, whether wild or domestic, trained or untrained, are not service animals under this definition. So this is the definition by HUD of what a service animal is. A lot of times we will see assistance animals over service animals. Occasionally you see service animals within the housing environments as well, but we see a lot more on the realm of assistance animals. And that is going to be a much more broad definition. And that can include those emotional support animals or those ESAs. When we see requests for reasonable accommodations related to those ESAs, some of those common issues that come up or common concerns that come up from a landlord are related to the documentation. And so the documentation from the internet, there are some websites that do sell certificates or registrations, licensing documents for assistance animals to anyone who answers certain questions or participates in some sort of interview and pays a fee for that. The Fair Housing Act, as well as the North Dakota laws, do indicate that they can request reliable documentation, that a landlord can request that reliable documentation. The kind of slippery slope or difficult piece of this is there are many legitimate licensed healthcare professionals that do deliver services remotely. So we see a lot of telehealth and kind of just those virtual services. So just because the documentation did come from the internet does not necessarily mean that it's not valid. And especially as kind of an interpretation of just a common individual interpretation, it can be very difficult to decipher whether or not it is a legitimate and reliable documentation or if it is just some sort of certification that's being provided from the internet. Some of those main things that you're looking for is you are looking for the healthcare professionals' knowledge of that individual's condition, kind of that confirmation on whether or not they are a person with a disability, whether or not they have that need for the service or assistance animal, and kind of indicating that request for the accommodation, what that medical necessity is for it. One thing that kind of can hang some people up is you do not need a specific medical diagnosis. You don't have to have the documentation that indicates what that person's actual diagnosis is, as long as the documentation that they provided does indicate, again, kind of that they are a person with a disability, and that this requested accommodation has that disability related need associated with it. I put this is a whole snippet of the law itself. This is one of our more recent changes to the fair housing laws in North Dakota. And this kind of reiterates that same mentality that HUD's guidance does of that reliable documentation. So this is the actual citation for it. And again, it talks about a landlord may require reliable supporting documentation be provided by a tenant of a rental dwelling that is subject to a no pets policy if the tenant asserts a disability requiring a service animal or assistance animal to be allowed as an accommodation on the rented premises under the provision of law. Reliable supporting documentation may be provided by a physician or medical professional who does not operate in the state solely to provide certification for service or assistance animals. And so, again, that reliable documentation must confirm that tenant's disability, the relationship between the tenant's disability and the need for the requested accommodation. Again, this is always just such a slippery slope because of the prevalence of telehealth, and even in situations where a tenant may have been under treatment in an entirely different state, and then when they move to North Dakota, they still have documentation from that state. That doesn't make that documentation invalid, again, as long as it's providing the information of the disability itself and then that disability related need for the accommodation. So, types of assistance animals. We get this question a lot of what exactly constitutes an assistance animal. Can it be anything? In short, it certainly could be. So, it can be cats, dogs, that's the ones we see probably the most common. We do see some of those household animals, maybe like guinea pigs or hamsters, maybe even some sort of reptiles, but it really can be a vast majority of different types of animals. Obviously, we don't see it as much in this state, but it can be things like monkeys, it can be other things. So it really is going to depend on the situation, but you could see really any type of animal in an assistance animal situation. Again, different than service animals because those are dogs, but assistance animals are going to be much more broad. So again, assistance animals, it is more limited in the fact that service animals are more limited. That's going to be that specific animal performing a task. But the animals for assistance animals, they're going to be animals commonly kept in the household. Again, dogs, cats, small birds, rabbits, hamsters, gerbil, rodents, fish, turtle, other common kind of domesticated animals that you'll commonly see kept in a home. Any of those can fall under that assistance animals. When it comes to unique animals, so there are certainly situations where you're going to see much more unique type of animals. Maybe this is in the form of like a chicken, or maybe it's in some sort of form of some sort of reptile. Maybe it's even something larger like a horse or something in that format. And when it comes to those unique animals, the HUD guidance does indicate that the requester has the substantial burden of demonstrating that disability related therapeutic need for that specific animal or type of animal. So there could be reasons why the individual does not have that kind of common cat, dog, regular household domesticated animal. Maybe it's for allergy reasons. Maybe it's because the individual has very specific required needs. So in the case, again, we don't see it often, but in the case of something like a monkey, maybe that monkey is specifically trained to provide very specific services for that individual. And so they are, grabbing things for them. They are administering things. Maybe they're grabbing straws and inputting it into the beverage, things like that. Maybe it has a very specific requirement for their disability to have only that type of animal. Again, they're going to kind of have an above and beyond requirement to demonstrate this is the only animal that I could have, and this is why. So this is kind of the additional documentation piece where it's going to go above and beyond just that, yes, they have a disability. Yes, they have a need for this animal based on their disability. They would have to have something further indicating why they need that specific animal. And these requests, obviously, we think a lot of the times they're going to fall under things like just the landlord, but they can absolutely apply to other housing situations as well. So it could be homeowners associations, it could be rules, it could be zoning laws. All of those things can come into play when it comes to these requests for reasonable accommodations related to those unique animals. Again, I think kind of the easy one to think of is maybe like an equine type of situation where there might be zoning laws, but there may be exceptions to those for that reasonable accommodation situation. So some of the common kind of defenses that we see with relation to service and assistance animals is the direct threat. And we'll talk a little bit more about this later. But when we're thinking about direct threats, yes, they absolutely can be viable reasons why an employer or landlord may deny a tenant a reasonable accommodation request. But when we're looking at those direct threats, they can't just be based on speculation or kind of those stereotypes to certain types of animals or certain breeds of animals. It really does have to have some sort of demonstrable reasoning as to why it's considered a direct threat. Some other things that come into play, city restrictions. There may be limitations within the city for either the number of animals or the type of animals or the breed of animal. And those are really going to come down to, again, as long as the tenant has some sort of documentation indicating the medical necessity for it, as well as that association to the disability, those might be issues that the tenant would take up with the city if there's some sort of city ordinance. For example, if there's like a breed restriction and the individual's emotional support animal is of a certain breed, they may have to address that with the city itself, that they're requesting an accommodation with the city for an exception to that certain breed restriction. Common areas. Again, these reasonable accommodations absolutely can't impact those common areas. If you have those specific areas or kind of pieces to a property, the tenant is to still be able to enjoy them the same as other tenants. And so those emotional support animals, those service animals certainly may come into play in some of those common areas. The requirements of the animals. So there's a lot of pet addendums or assistance animal addendums that we see that require the tenant to spay or neuter their pet. Or again, certain breed restrictions, maybe weight limitations, maybe size limitations of they can't have a certain breed of dog because it's too large for the property. Those are going to be kind of difficult to prove that a landlord has to have those as part of, kind of that undue hardship piece, because they're putting additional steps or barriers in place for a person with a disability that the person is requesting that exception from. So even though, they may say, well, this is my process for all animals that are on our property. Again, having those above and beyond conditions of you have to have these in place in order for us to grant your accommodation, those may not be permissible under the law. That being said, expectations of behavior absolutely are something that a landlord can still maintain. You can still have expectations on how the animal is behaving in those common areas or in the unit itself. If they are, not cleaning up after the animal or the animal is never leashed, those may be behavioral issues that just as you wouldn't permit a tenant to have unlimited loud parties and disrupt the enjoyments of other people's properties just because they were in a wheelchair. The same goes with individuals, even though they may be having that accommodation, it doesn't negate the fact that they still have expectations within the property. So you can absolutely have expectations of the behavior of the animals. So what if another tenant also has a disability, such as allergies, that won't allow for the service animal to be in the unit? These are absolutely going to be a case-by-case basis issue that you may have to assess both disabilities and try to make accommodations that would work for both tenants. I know that is not easy, and I know that that can seem, kind of like that uphill battle and just really difficult thing to overcome. But that is how those you kind of have to assess it like two separate reasonable accommodation requests. And so just because the next door neighbor requested, hey, I have allergies, you have to look at both situations to see if you can make remedies that would resolve it for both parties. So can requests be denied? Kind of as you've probably gathered as we've gone along, yes, absolutely, requests can be denied. There are going to be reasons why a request would be denied. Maybe there isn't any sort of medical necessity for the animal, or they refuse to kind of provide that interactive process of that back and forth to try to come to some sort of resolution. Maybe it's going to be that undue hardship. So when you think about that request, does it impose that undue financial or administrative burden? So is it going to completely alter, or is it going to be something that just financially we can't do? Or in order to do this, we would have to entirely hire a new staff person or multiple staff people to be able to handle this request. That may not be a reasonable request at that point. Would making the accommodation or the modification require a fundamental operational change? Then there may be reasons, if the answer is yes to that, you may not be able to provide that accommodation. Again, you still may have to explore other options, but when it comes to those accommodations, it doesn't always have to specifically be the requested accommodation as long as it's effective. So again, if it is one of those undue hardships, or it just is going to completely alter the nature of the business, then yes, you may say, no, we cannot grant that accommodation. But hey, we looked into it. These are things that we possibly can provide you that might be effective. So that direct threat, again, we hear this occasionally. It's not too often that this is a respondent's defense, but if it is used, again, it's going to be looked at very closely of, are they just making this assessment based on that speculation, or is it off of some actual indication of a direct threat? You don't have to wait for something to happen in order to say, well, see, yes, now it is a direct threat, but you do have to kind of take into account the actual factors that of why you're saying maybe you believe that the dog is vicious, or that it is going to attack somebody. Has it been observed that the animal has behaved in certain ways? Does the animal have some sort of history of, they were banned from the last city they were in due to vicious dog nature? You have to take into account that nature, duration, and severity of the risk of injury. You have to look at the probability that injury will occur, and whether there are other reasonable accommodations that would eliminate that direct threat. So again, really just making sure you're not making this assessment based solely on that fear or speculation or stereotype, when in reality, maybe that isn't at all accurate. There's no documentation, or really no indication that the animal is a direct threat, but the respondent used that as their defense. It's going to be something that would be looked at quite closely. So can a landlord ask for documentation? The short answer is maybe. In certain situations, absolutely you can ask for additional documentation. If it is not clear, if there is, really some sort of documentation is very lacking, maybe it's just a doctor's note that says, I saw this patient. Well, that doesn't indicate whether or not the person is a person with a disability. It doesn't indicate whether or not the animal is medically necessary for their disability. So that might not be enough information, and you may need additional documentation. Maybe it's that the tenant is requesting a reasonable accommodation where you're going, well, I just need documentation indicating why you need 4 dogs versus the one dog that you've had previously. You may have kind of those certain situations where it's not either visibly obvious or it's not, the documentation they provided does not indicate enough as to why there's that medical necessity for it. So you may have reason or need for additional documentation. That being said, if it is something visibly obvious, if you have an individual that comes in and they are clearly seeing impaired and they have a seeing eye dog, to request additional documentation verifying that person's disability and the disability related need for that animal may be unnecessary. And that in and of itself can be problematic. But there's absolutely situations where a landlord would and could ask for additional documentation. So again, if the documentation received for the accommodation is not clear, you can ask for that additional documentation. Really, the big thing to keep in mind here is you're not the doctor. If the doctor, the medical provider, whomever it is that issued that note makes a clear connection between the requested reasonable accommodation and that disability, you cannot ask for more. So unless you can prove that undue hardship or that direct threat, generally speaking, you're going to have to provide that reasonable accommodation. So um, documentation is something that we see not necessarily of, sometimes the individual, the tenant may not have provided in any documentation or refuses to provide documentation. But in a lot of situations that we see, it's kind of the back and forth between the landlord and the tenant, and the landlord saying, well, I need more. I need to know what your disability is. I want to know why you need to have this dog. What you've provided just is very vague. I want more information. That may not be always legal, because if the documentation that was provided does indicate it that disability related need, there may not be a need for additional documentation. So again, kind of touching base just on the various types of animals, there can be a whole array of different assistance animals. Just because we kind of theoretically think of cats and dogs as being those most common ones, there's absolutely going to be situations where other types of assistance animals may come into play. HUD does have some excellent guidance on reasonable accommodations and specifically service animals. In 2020, they did have a, kind of a notice, I guess, but it's a question to answer. It's a very user-friendly format, and it talks about kind of what to look for when it comes to service or assistance animals. And so it really is a yes or no. Does the individual have this? Do they have that? Is it a dog? If yes, then move to this question. So it's very user friendly and has some great additional documentation and guidance on what to be looking for, what you are permitted and not permitted to do as a landlord or ask for. So that 2020 guidance is really, really helpful. But their 2004 reasonable accommodation, their joint statement, the Department of Justice, as well as their 2013 guidance, really is helpful on providing kind of a go-to guide, a very user-friendly guide on what to look for, what to ask for, and kind of things to keep in mind when you're talking about those reasonable accommodations. Just kind of put this in there additionally, because we definitely see this quite often, is when it comes to those reasonable accommodations requests, it's important to keep in mind that even if you, let's say maybe there were some issues that happened through the process or through that reasonable accommodation process, you determined that the individual did not need the requested accommodation, or that the reasonable accommodation was not reasonable, there was some sort of undue hardship. It's always good to keep in mind the kind of the retaliation side of things, because it is a commonly filed on complaint in our office, and it is based on what we call participation in a protected activity. So if an individual requests a reasonable accommodation or files a complaint with our office, and as a result of that, the landlord takes some sort of retaliatory action against them, they can file on that issue, because retaliation is one of those issues that we do have jurisdiction over. So why would somebody retaliate if they obviously know that it's against the law? oftentimes it can be that they feel slighted. Maybe in the case of that reasonable accommodation request, they feel like the tenant has been maybe untruthful, or they feel they've been combative, or they haven't really worked with the respondent when it came to that interactive process. And so their kind of natural inclination is, we've got to get rid of this tenant. They're not good tenants. We don't want them anymore. All they're doing is causing issues. They're filing complaints with the department. And so there may be kind of that defense mechanism of, I'm just trying to protect myself. I'm trying to make sure that this doesn't happen either further or to, with future tenants. And so that is why retaliation occasionally can happen. But the actions themselves can be very serious. They can, sometimes landlords don't realize things like those offhanded comments or that bullying that can be viewed as retaliation. So even though it may just be kind of that self-deflection, that human reaction, it may be retaliatory action as well. So if a tenant files a complaint, kind of what is that? What happens? What's that process look like? So one thing I always like to mention to all parties is anybody that believes they have been discriminated against has a right to file a complaint with our office. They do have to have that nexus or that connection between whatever the action is and then their alleged protected category. So they have to allege that, because of my race or because of my disability, this action occurred, and this is why I believe that happened. They have to have that kind of connector between the two. But generally speaking, as long as it's filed within that statute of limitations and those allegations kind of are pointed in the direction of I believe I was discriminated against, and these are the reasons why, then that's enough for us to write the complaint. The department does always act as a neutral party in these complaints. So we always just are the middleman. We're taking the facts and evidence and comparing them to the law. And so again, when that complaint comes in, we're assessing it first and foremost to see, do we have authority over it? Are the allegations within our jurisdiction? Are they having that connection between the protected category and the discriminatory action? If so, then we would file the complaint. We'd send it on to the respondent to provide their response, and then it would proceed for the investigation. We always act as that neutral party. Conciliation is something that would be offered throughout the process. So at any point during the process, either party can present any sort of resolution offer. Again, it can be monetary, it can be training, it can be allowing the tenant to leave the lease, it can be granting the accommodation. We have a lot of cases, obviously, that resolve through that conciliation process, and it's something that is going to be emphasized and offered throughout the process. Once we complete an investigation, we either determine based on the facts and evidence a violation of the law did occur, or based on the facts and evidence a violation did not occur. And based on that, if we do believe a violation of law occurred, then we would issue a charge, and there's basically court proceedings thereafter. If we do not believe a violation of law occurred, then the case would be dismissed with our department, and the department would have no further action on the issues. So how do you know what not to do? Obviously, know the law is going to be the easiest way to prevent these issues. Participating in trainings like this, or just kind of self-educating yourself through those fact sheets, those joint statements on HUD's website, those are going to be great steps on kind of understanding the law more and being able to really make sure that you are in compliance with the law. But if you are not sure what to do in a scenario, the department is great at providing, kind of pointing you in the right direction, providing what the law is. But because these situations are so case by case, it is going to be difficult to call us and ask for advice. We can't provide advice or guidance. So contacting an attorney that's knowledgeable in fair housing laws will help a ton in that realm. Make sure you're training your managers and staff, especially the individuals that are going to be working with the public and having that public contact, making sure to go over, these are, if somebody makes that reasonable accommodation request, these are the steps we take, or this is the information that you need to bring to this person to move forward with that process. Avoid those sudden rash decisions. Really take time to think through and evaluate the request before jumping to the instant conclusion of no. There may be, some requests that come through for certain types of animals or certain requests that you are kind of just gut reaction is, oh no, no, we would never do that. That sounds awful. We wouldn't go, we wouldn't have that many animals, or we wouldn't allow that kind of accommodation request. Instead of that instant reaction of no, really evaluating the request to understand, is there that really extensive medical necessity? If it is one of those unique animals, does the extensive documentation indicate the medical related reasoning for it? Really looking at that reasonable accommodation process. And if you're going to say no, what is the reasoning for it? Is it one of those undue burdens? Is it going to be financially burdensome? That type of thing. You really need to assess those pieces of it. Be consistent. This is going to be something that it not only will help to ensure that you're being fair to all tenants, but it also will really flag in your brain if you are doing things consistently and following your policies and procedures. When things do not go according to the policy or procedure, it will stand out like a sore thumb to you. You will see absolutely that something is missing in that process. So having that consistency will always help. Document everything. In the day and age where everything is documentable, you have text messages, you have emails, you have those memos to tenants. Really documenting everything is going to be extremely helpful. If in the case that a complaint is filed, you can certainly provide the documentation supporting it. Again, reaching out to the HUD website, looking at that guidance that they have, looking at our Department of Labor's websites for our brochures, our fact sheets, just to get a better understanding will always help. And lastly, be nice. It seems silly, but we really do not see complainants that come through our office that really are very happy with their living situation. They have no reason that they want to leave or change things, but they just feel like they have to file a complaint. Really having good communication with your tenants, having them understand why you're doing certain things will absolutely help that interactive process between the parties. It won't necessarily prevent a complaint from being filed, but it certainly will hopefully lessen the likelihood of that. So that is all I have for you guys. If you guys do have any questions, you can absolutely either put them in the chat and we can go through those. But otherwise, our website is up here, our direct phone number. Like I said, we really do try to point you guys in the right direction. Can't provide that advice or guidance on those specific situations, but we certainly do try to get you on the right path to make those decisions and really make that a smooth process.
We do have a couple questions. First one, they were wondering if you could share your slides.
I can do a PDF of it. The biggest nuance of it is just know that this is the relevant information at this current time. So if anything changes law-wise, anything like that, obviously they change a little.
Okay. Second question, are miniature horses still considered service animals, or is it just dogs now?
On HUD's guidance, it is just for solely for dogs, but there's definitely information out there that also talks about for the like the miniature horses that are specifically and specialty trained, that type of thing. They do have information on that. So off of HUD's website, it's just dogs, but I know that there is kind of just a cliff note of sorts that brings you to other information about some of those more unique, like the service horses, the miniature horses.
When there's breed restrictions with the insurance companies, do the insurance companies ask for a reasonable accommodation, or how is that handled?
So it can technically on our front, they can file against the landlord and the insurance company. When it comes to, there's a whole other set of HUD guidance that is on insurance providers. And honestly, being I don't know exactly where it is on HUD's website right now, if you just Google HUD and insurance breed restrictions, it does bring you up to the guidance from HUD. But really what it comes down to is kind of that same undue hardship test, but just in the realm of insurance. So was the insurance provider going to alter or change the policy to the point where, it would alter the business functions or that business nature of the housing establishment? And were there other options for insurance that was like or similar that would not have, that would have been accessible? So maybe it's, let's say you have an insurance provider that only provides coverage in just your town and that's it. There's no other providers. Then it may be unreasonable because there's no other options for the insurance side of things.
Okay, thank you. Next one is, with the city breed restrictions, would the tenant or would the landlord ask for the reasonable accommodation?
Generally the tenant would. So in those situations, if the landlord is the one that denies the reasonable accommodation because of the city restriction, it may not necessarily be a viable defense for the landlord because it really is an issue with the city and the tenant. And the tenant can request the reasonable accommodation for that specific breed to the city. So most of the cities that have those breed restrictions, they should have exceptions for reasonable accommodations or kind of a reasonable accommodation process within the city ordinance. And if they don't, then the tenant can file a discrimination complaint against the city in that situation.
Okay. Okay, next one. With telehealth providers, are we permitted to request information about what telehealth service website they use to help us to prevent people from using websites that allow them to pay fees to obtain supporting documentation from a provider that does not have knowledge of their disability? If a tenant provides us with a letter from a provider that lists a website that clearly exists to sell ESA documentation and does not offer any other therapy or services, would we be permitted to request, hang on a second, additional supporting documentation to assess the need for the accommodation? Are there resources for landlords that recommendations or guidelines on how to review letters provided by virtual providers to determine what is acceptable means of ESA supporting documentation?
This is, as you may expect, an extremely tough question because when it comes to sometimes when those changes happen in the laws of, for example, between HUD and our state law, where we indicated that they do have to have that reliable documentation, that they can't utilize something that solely has the purpose of the just providing kind of a for payment to get your ESA letter. That is one that really a lot of those types of cases kind of either have to go through the courts to really establish what was viable or not. It absolutely could be a defense of the respondent saying, we did have documentation and evidence that this is solely a provider that its only function is to provide ESA letters for payment. Then that certainly could be the respondent's defense. The problem is like I said, because it can be such a murky situation, even kind of finding, okay, well, we found information on the internet and this is all that this provider provides are ESA notes. They still may be a valid provider. It just really is going to kind of it's going to depend on the circumstances and the situation. And it's something I personally think if it comes through our department and it really wasn't on the fence of we do believe that there was evidence that it is solely there for just for purchase ESA letters, basically, or on the flip side, that we do believe it is providing health services. Those are things I believe that will go to the courts of it ultimately, and that will give more of that guidance on what is quote unquote reliable documentation, just because it can be kind of a case by case, really interpretation by interpretation scenario.
Okay. And then we've got one more in the chat here. Can we deny an ESA letter if the dog attacked another dog on the property?
Certainly, you may potentially have that direct threat issue. Like I said, especially if it is something that's a kind of, yes, a demonstrable instance of them being a direct threat. Again, it could be situational, so it may not necessarily fall under that direct threat. The HUD, again, has great guidance on direct threat information, but that it certainly could fall under that direct threat scenario. It just depends on kind of the totality of it, because it could be, it was one instance and the other animal is actually the one that attacked them and things like that. Like, there could be circumstances that would absolutely change it to not being a direct threat. But yes, there could be reasons why a situation like that could be seen as a direct threat.
Hey, that looks like that was the last question in the chat. So,
all right. Well, I will forward the slides. I'll just forward the PDF, the slides to you, Cheryl, and then you can distribute it if need be, or put it up somewhere if people want to access it.
okay, yep, we'll send it out to the listserv for the
Perfect.
for the trainings. I appreciate you taking all the time to meet with us and share your information with us again.
Yes. Thank you, guys. Have a wonderful afternoon.
Thank you. Bye.